The 6th of April 2022 was a monumental day in family law as we saw the introduction of the Divorce, Dissolution and Separation Act 2020, which has now changed the law relating to divorce and the dissolution of civil partnerships. So what was the previous position? As you know, there's one ground for divorce, which is that the marriage has broken down irretrievably. But previously, to establish this, you had to rely on one of 5 facts of either adultery, unreasonable behaviour, desertion, 2 years separation or 5 years separation. Now that meant that if you hadn't been separated for 2 years or more, and in the absence of adultery, you had no choice but to petition for a divorce based on your spouse's unreasonable behaviour. So how will no-fault divorce work? The introduction of no-fault divorce will remove the requirement to provide evidence of unreasonable behaviour or separation, and it's now possible to apply for divorce by providing a simple statement of irretrievable breakdown of the marriage or civil partnership. Also, it will no longer be possible to defend a divorce unless there is a dispute in relation to jurisdiction or the validity of the marriage or civil partnership. The language relating to the divorce proceedings has also been updated so that petition will become application, petitioner will become applicant, decree nisi will become conditional order, and decree absolute will become final order, which should make things a little easier to understand. Now, joint applications will also be allowed for the very first time, which means that couples will be able to apply together for a divorce or a dissolution, which will hopefully remove some of the contention and stress from the process. The changes will also introduce a new time frame, meaning that you can now be divorced within 6 months, which will be made up of a minimum period of 20 weeks from the application being issued until the conditional order can be applied for, and a further 6-week period from the conditional order when the order can be made final. So why is all of this better? It's anticipated that the no-fault divorce bill will help reduce conflict and allow couples to focus on important matters such as sorting out arrangements for their children or finances. It's also hoped that the new law will allow separating couples to work together amicably and to resolve issues that arise on separation. So how long do you have to be separated to get a no-fault divorce? To apply for a divorce or dissolution, you must have been married for at least 1 year and must meet certain resident conditions or must be domiciled here. Our team of specialist family law solicitors are also accredited with Resolution and are committed to working as constructively as possible, hopefully limiting the stress to you during what can be a very difficult time. The introduction of no-fault divorce will allow us to take this one step further, as it will hopefully limit the acrimony in the process. If you have any questions or would like more information on no-fault divorce, please do not hesitate to contact us on 0161 941 4000 or email lawyers@myerson.co.uk.